as I have mentioned, they are independent also in a material point of view. While functioning their job, they are subject only to the law and not to any other authority. The court in Israel, and including the Supreme Court, enjoys much confidence and trust by the public. And it's very important for us as judges to have this confidence, because we think that we take our strength, we derive our strength from this public, and it's very important for us, this public confidence. The Supreme Court of the State of Israel is the busiest court in the world. While comparing our court concerning number of cases filed to our court with other two courts in the United States and Great Britain, while in both countries, in your country and in Great Britain, there are about 80 and maximum 100 cases every year heard by the Supreme Court. In Israel, the number of cases about 10,000. Yes, it's unbelievable, but it's a reality, and it's a matter of fact, you know. And the main reason is because in our country is the only place in the world while every citizen or any resident in the state may apply directly to the Supreme Court. Something which will not happen in any other place in the world. First of all, the court opens its doors to everyone claiming violation of rights or human rights by one of the branches of the government while operating in the public arena. And this kind of cases, we have about 4,000 cases every year. Although for us it's a hard work, hard job, and working actually very hard, sometimes 12 hours a day, all the judges. But at the same time, we don't complain, because we want to give the feeling to every citizen in the state that somebody hears him and his rights are protected. Because the human rights issues in Israel is in a major concern by the public and by the court. And hundreds of cases filed to our court concerning human rights issues. Everyone may apply to the court even without the assistance of an attorney, you know. He can write it in his handwriting and deliver it to the court. He pays the fees, which sometimes is about $500 only. And he has the privilege to appear before a panel of 3 judges of the Supreme Court, arguing, asking questions, answering questions of the justices, and he goes home at the end of the day and tell his neighbors, you know, this day I was privileged to appear before 3 justices of the Supreme Court. And for him, it's a very important event. And the public in our country appreciated very much that everyone may come to talk to and to argue and to ask questions to the courts. This is very important. And for this reason, we have so many cases. The Supreme Court has 2 functions. I have mentioned it is, as I mentioned, the first and last instance in those cases against the state. And the other function is, it is the Court of Appeal on the judgments of the lower courts. And because we do not have appellate degree between the district court and the high court, we have 3 levels of courts in the country. The first level is the magistrate court, which has a jurisdiction in criminal cases up to 7 years imprisonment, and in civil cases up to a sum of $500,000. Above that, there is a district court, which is at the same time the Court of Appeal on the judgments of the magistrate courts, and at the same time the first instance and unlimited jurisdiction in criminal and civil cases. And above is the Supreme Court, which is the Court of Appeal on the judgments of the district courts. At the same time, we call it the High Court of Justice, where every citizen may apply to the court. We do not have the appellate degree between the district court and the Supreme Court. For this reason, we have those number of cases, appeal cases every year. Another very unique jurisdiction to our Supreme Court is that there is the right to the President of the Court to order a further hearing on a judgment given by the Supreme Court itself. But usually in every place in the world, the ruling of the Supreme Court is the last one. It's binding all the courts, and it is the last instance, last station. But in very rare cases, one of the parties who lost his case in the Supreme Court in a panel of 3 judges may apply to the President asking for further hearing of this specific case, and then the President could expand the panel up to 5 or 7, 11 or 13 judges to hear once more the appeal on the judgment of the court itself. And we have had 1 month ago a very important issue in our country. It was in the interest of the public, where an adoption case. You know, the adoption cases, if you ask me sometimes, what is the most difficult cases you have dealt ever, I say it is the adoption case. It's much more difficult than the murder cases, because you should decide to take this child from his biological mother and take it to the adoption family, you know. And for this reason, there was a case that a child was taken from her biological mother because the mother used to use drugs, and she applied, the mother applied to the family court in order to take back her child, and she lost her case, and she appealed to the Court of Appeal and lost her case. And then she appealed to the Supreme Court, and the Supreme Court decided to accept the appeal and ordered to give back the child to her biological mother. Then the state asked the President for further hearing on this case, and the President of our court decided a panel of 11 judges. And 2 days before I came to your country, we delivered our ruling. It was in a majority of 6 judges against 5. You know, it's because it's a very sensitive issue, and all the judges gave their opinion. Usually in a regular case, the presiding judge asks one of his colleagues to write the opinion, and if the other 2 agree, they write, I agree, and that's all. But in very important cases, all of the judges, although they agree or disagree with the result of the presiding judge, they may add their opinion also. And it was hundreds of pages, this opinion, because it was very, very important. This is the special procedure of further hearings. Another unique jurisdiction to the Supreme Court is to order a retrial. And I think while talking about the rights of the individual, it's very important to know that in our country, if a defendant was found guilty and he appealed, and he also was found guilty, after many years, if he found a new evidence that he couldn't have the opportunity to bring it before the trial judge, then he can now ask for retrial because he found a new evidence. And it's very important to know that we have had, during the last 50 years, about 5 or 6 cases where after this retrial was held, he was found innocent. This is the very unique procedure of retrial.